Welcome to The Explainer, where we turn documents into stories. Okay, so today we're digging into a real head-scratcher, kind of like a legal ghost story about a huge international lawsuit that just, poof, vanished. All right, take a good look at this. What you're seeing is a court order from the International Court of Justice, dated January 30th, 2001. Now, on the surface, yeah, it looks like pretty standard, maybe even boring procedural paperwork. But trust me, this single page is the final act in a high-stakes international drama that simply disappeared. So what on earth happened? And that's the big question we're going to answer, right? How does a super serious charge, a case of armed aggression between two countries, get completely wiped off the books at the world's highest court? Well, the answer isn't in some splashy headline. It's buried right here, in the official court filings. So let's follow the paper trail together. To figure out how it all ended, we've got to go back to where it all started. So let's jump in our time machine and head back to the summer of '99. And boom, here we are. This is the document that kicked the whole thing off. On June 23, 1999, the Democratic Republic of the Congo, we'll call them the DRC, filed this application, officially starting a legal battle against its neighbor, the Republic of Burundi. And listen, this was no small disagreement. The DRC's accusation, which you can see quoted right from their filing, was incredibly serious. They were alleging acts of armed aggression in flagrant violation of the United Nations Charter. I mean, these are some of the heaviest charges one nation can throw at another. But you'd think they'd start talking about troops and battles, right? Nope. The case immediately slammed into this huge legal wall before the real argument could even get started. And that wall? It all came down to one single powerful legal idea: jurisdiction. Now, it sounds complicated, but really, it just means who has the authority here? The big question wasn't if Burundi did it, but whether the International Court of Justice even had the power to hear the case at all. So right away, you've got a standoff. On one side, the DRC is arguing, yes, the court absolutely has jurisdiction, look at all these international treaties. But on the other side, Burundi's response was a firm and simple no. They argued they had never, ever consented to the court's authority on this kind of issue. So you see, the very first fight wasn't about the conflict, it was about the court itself. So with both sides completely dug in, the court had to make a call. And what they did was essentially hit the pause button on the whole armed aggression thing. Before anything else could happen, they said this question of jurisdiction has to be sorted out. And this is where things really change. That dramatic accusation, it slows way, way down and turns into this methodical procedural battle. The action moves from the battlefield to the archives, fought with written arguments and strict deadlines. Let's walk through the timeline, see how this all played out. Back in October '99, the court sets the schedule. By April 2000, Burundi files its official argument against the court's jurisdiction. The DRC was supposed to reply by that October, but, well, they asked for more time, which pushed their new deadline into early 2001. And this doc right here, this is the official proof of that delay. It's the court's order from October 2000, formally giving the DRC that extension until January 23, 2001. So everyone's waiting, right? What's the DRC's big decisive counterargument going to be? But just as that new deadline was creeping up, the whole thing takes a turn that nobody saw coming. Okay, so the clock is ticking down. The deadline is January 23rd. But then on January 15th, just 8 days before their crucial legal argument was due, the court gets a letter. And inside that letter is this bombshell phrase, which we've pulled right from the final order. The DRC informed the court that its government wished to discontinue the proceedings. Can you believe it? After all that time, the country that filed the lawsuit wanted to drop it? So, what happens then? Well, it's actually a pretty straightforward process. Step 1, the DRC tells the court they're out. Step 2, the court turns to Burundi and basically asks any objections. And step 3, Burundi writes back and, probably not too surprisingly, says, nope, we're good with that. And with both sides, the accuser and the accused, agreeing to just end it, there was really only one last thing for the court to do. And that brings us right back to the very first document we looked at. This is that key passage from the final order. It officially notes the DRC's request to drop the case and Burundi's agreement. The legal loop is officially closed. So with everyone on the same page, the court typed out its final command. Just 9 little words. Orders that the case be removed from the list. And just like that, it was over. Gone. So what did we learn from following this paper trail? Well, the real legal fight was never actually about the aggression itself, was it? It was all about jurisdiction. And the whole thing ended because the DRC, the accuser, pulled out before it ever had to make its final argument on that point. So our mystery is solved. The lawsuit vanished simply because the party that brought it decided to walk away. But that leaves us with one last big thought. The legal file is officially closed, for sure. But these documents are totally silent on the most important question of all. Why? Why did the DRC withdraw its case? The paper trail tells us exactly how the case disappeared, but it gives us zero clues about the reason. And because it all ended on a technicality, that explosive charge of armed aggression was never argued, never judged, and to this day, it's still just hanging out there, officially unresolved.